I never thought my firewood would become the center of a legal battle that would expose the darkest side of suburban politics. But that's exactly what happened when Patricia Garrison decided she owned everything in our community. My name is Keith Armstrong, and I had been living in the Pine Ridge Estates community in Boulder, Colorado for 3 years before everything went sideways. The homeowners association there was strict, sure, but nothing prepared me for what would happen during the winter of 2024. I worked as a software engineer from home, which meant I spent a lot of time in my house, and I had grown to appreciate the cozy warmth of my wood-burning fireplace during those brutal Colorado winters. It wasn't just about the heat. There was something therapeutic about chopping wood, stacking it, and watching the flames dance in the fireplace while I worked on code late into the night. In September of that year, I had ordered 2 full cords of premium seasoned oak from a supplier in Lyons. That's a lot of wood, roughly 512 cubic feet when properly stacked, and it cost me nearly $800. I had it delivered and carefully stacked in my assigned storage unit in the community storage facility. These units were part of the HOA amenities, small enclosed spaces with roll-up doors where residents could store outdoor equipment, seasonal decorations, and other items that didn't fit in their garages. Patricia Garrison was the HOA president, a 52-year-old woman with severely highlighted blonde hair that she kept in a perpetual bob cut, the kind that screamed for a manager at every retail establishment in a 50-mile radius. She had been running the Pine Ridge Estates HOA like her personal fiefdom for 6 years, and most residents had learned to just stay out of her way. She drove a white Mercedes SUV with a vanity plate that read Rules 1 Cent and had a habit of patrolling the neighborhood with a clipboard, documenting any violation she could find, real or imagined. The first time I noticed something was wrong was in early November. I had gone to my storage unit to grab some firewood for the weekend. I had been using it sparingly, maybe taking enough for 2 or 3 fires a week, so I knew roughly how much should have been there. When I rolled up the door, I immediately saw that a significant amount was missing. At first, I thought maybe I had miscalculated or perhaps I had been using more than I thought. But the more I looked at it, the more certain I became. Someone had taken at least a quarter cord of my wood. I checked the lock on the unit. It was intact, showing no signs of forced entry. That meant someone with a key had been inside. The HOA board members all had master keys to the storage units, something they claimed was necessary for emergency access and maintenance. I felt my stomach drop as the realization hit me. This wasn't a random theft. This was someone with authority. I decided to set up a wildlife camera. I had one left over from a camping trip that could record motion-activated video. I positioned it carefully in the back corner of my storage unit, hidden behind some old camping equipment, but with a clear view of my firewood stack and the entrance. The camera had a battery that could last for weeks, and it stored footage on an SD card. If someone came back for more wood, I would have proof. I didn't have to wait long. 3 days later, I checked the camera and found exactly what I had suspected. The footage was crystal clear. Patricia Garrison herself, wearing her signature black North Face jacket and designer jeans, had entered my storage unit at 9:30 in the morning on a Tuesday. She had pulled up in a small utility cart that the HOA used for maintenance purposes, and she proceeded to load up approximately 40 pieces of my oak firewood. The video showed her making 2 trips, carefully stacking the wood in the cart, and then driving away toward the far end of the community where she lived. I sat in my storage unit, watching the footage on my phone, feeling a mix of anger and disbelief. The HOA president was stealing from me. Not borrowing, not mistakenly taking, but deliberately stealing firewood that I had paid for with my own money. And she was using her position and her access to do it. My first instinct was to confront her directly, but something stopped me. This woman had power in the community, and I had learned from watching other disputes that she wasn't someone who admitted fault easily. I needed to handle this the right way. I decided to document everything first and build an airtight case before making any moves. Over the next 2 weeks, I let the camera run continuously. Patricia returned 4 more times. Each visit was captured in high-definition video, showing her entering my unit, taking my firewood, and loading it into the HOA cart. She never looked nervous or guilty. She moved with the confidence of someone who believed she was entitled to whatever she wanted. By the time I decided to act, she had stolen approximately half a cord of wood, worth about $200. I made copies of all the video footage, backed it up to 3 different cloud storage accounts, and downloaded it to 2 separate USB drives. Then, I went to the Boulder County Sheriff's Office to file a report. I wasn't sure if they would take a firewood theft seriously, but I figured I needed an official record of the crime. The deputy who took my report was a woman in her 30s named Officer Jennifer Martinez. She listened to my story with growing interest, especially when I mentioned that the thief was the HOA president. When I showed her the video footage on my phone, her eyebrows shot up. "This is pretty clear-cut," she said, watching Patricia load my firewood for the 3rd time in the compilation I had created. "That's definitely theft. The value you're describing puts it in the misdemeanor range, but it's still a crime." "What are my options?" I asked. "Well, you can press charges, which we can facilitate. But honestly, given the relationship here and the HOA involvement, you might want to consider small claims court as well. That way you can recover your losses and potentially get additional damages." She helped me file the official police report and gave me a case number. Then she suggested I contact a lawyer to discuss my options. As I left the sheriff's office, I felt vindicated but also anxious. I was about to go to war with the most powerful person in my community, and I knew it wasn't going to be pretty. I found a lawyer through a friend's recommendation, a guy named Robert Chen who specialized in property disputes and HOA issues. His office was in downtown Boulder, in one of those renovated historic buildings near Pearl Street. When I met with him 2 days later, he reviewed all my documentation with the careful attention of someone who had seen this kind of thing before. "HOA board members abusing their power isn't uncommon," Robert said, leaning back in his chair. "But this is particularly brazen. She's literally on camera committing theft multiple times. The question is, how do you want to handle it?" "I want my wood back. I want compensation for what she's already burned, and I want to make sure she can't do this to anyone else," I said. Robert nodded. Colorado law allows for treble damages in cases of theft, meaning the court can award you 3 times the actual value of what was stolen if the theft was willful and malicious. Given that she's the HOA president and used her position to access your property, I think we have a strong case for that. Treble damages. So 3 times what she stole, exactly. Plus court costs, plus potentially your attorney fees if the judge decides to award them. And given the video evidence, I'd say our chances are excellent. But here's what I suggest. First, we send her a formal demand letter. We lay out what we have, what we know she did, and we give her the opportunity to make this right before we go to court. If she's smart, she'll settle. If she's not, we file in small claims court and let a judge sort it out. I agreed to his approach. Robert drafted a detailed demand letter that outlined every instance of theft captured on video. included still frames from the footage, and demanded the return of all stolen firewood plus $400 in compensation for what had already been used, along with the cost of the security camera and my time dealing with the issue. The letter gave Patricia 14 days to respond. Robert sent the letter via certified mail to Patricia's home address and to the HOA office. Then we waited. I continued to monitor my storage unit with the camera, but Patricia didn't return. I suspected she had taken enough wood to last her through the early winter and hadn't planned on coming back for a while. 6 days after we sent the letter, I got a response, but not from Patricia directly. Instead, I received a notice from the HOA board scheduling a disciplinary hearing regarding unauthorized recording devices on HOA property. The hearing was mandatory, they claimed, and failure to attend could result in fines. I called Robert immediately. "They're trying to flip this around on me," I said, reading him the notice over the phone. "That's exactly what they're doing," Robert confirmed. "Don't worry. This is actually good for us. It shows consciousness of guilt. She knows she's caught, so she's trying to intimidate you and muddy the waters. We're going to that hearing, and I'm coming with you." The hearing was scheduled for a Thursday evening at 7 o'clock in the community clubhouse. I arrived with Robert, both of us dressed in business casual attire, carrying a briefcase with printed copies of all our evidence. The clubhouse was one of those generic suburban amenity buildings with beige walls, cheap carpet, and fluorescent lighting that made everyone look slightly ill. Patricia was there, sitting at the head of a long folding table with 4 other board members flanking her. I recognized 2 of them: Marcus Webb, the treasurer, a nervous-looking accountant in his 40s, and Sandra Phelps, the secretary, a retired teacher who always seemed uncomfortable with Patricia's aggressive management style. The other 2 were newer board members I had only seen in passing. "Mr. Armstrong," Patricia began, her voice dripping with false formality, "thank you for attending this hearing. We have serious concerns about your conduct." Robert held up his hand before she could continue. "Before we begin, let me introduce myself. I'm Robert Chen, Mr. Armstrong's legal counsel, and I want to make it clear that this hearing has no legal standing. My client is here as a courtesy, but he is under no obligation to participate in what amounts to an intimidation tactic designed to cover up your criminal conduct." Patricia's face turned red. "Excuse me, criminal conduct? I don't know what you're talking about, but Mr. Armstrong has violated HOA rules by installing surveillance equipment without permission. Mrs. Garrison, my client installed a security camera inside his own storage unit on property that he has exclusive use rights to under his HOA agreement. There is no rule prohibiting such cameras, and even if there were, such a rule would be superseded by his right to protect his property from theft. Which brings us to the real issue here." Robert opened his briefcase and pulled out a manila folder. He placed it on the table and slid it toward the board members. "This folder contains still images from security footage showing you, Mrs. Garrison, entering my client's storage unit on multiple occasions and stealing his firewood. We have video documentation of at least 6 separate instances of theft, totaling approximately half a cord of seasoned oak worth over $200. The other board members leaned forward, looking at the images. I watched their faces change from confusion to shock to embarrassment. Marcus Webb actually gasped when he saw one particularly clear shot of Patricia loading wood into the HOA maintenance cart. "This is ridiculous," Patricia sputtered. "That wood was abandoned. The storage units aren't meant for long-term storage of materials like that." "Really?" Robert said calmly. "Can you show me where in the HOA bylaws it says that? Because I've reviewed them thoroughly and there's no such restriction. Also, abandoned property doesn't mean you can take it for personal use. Even if it were abandoned, which it clearly wasn't, as my client has been actively using the firewood all season, you would have no right to claim it for yourself. Sandra Phelps spoke up, her voice quiet but firm. Patricia, is this true? Did you take his firewood? I thought it was community property, Patricia said, but her voice had lost its authoritative edge. The storage facilities are HOA property, and I assumed unclaimed items could be used for community purposes. For community purposes. I spoke for the first time, unable to contain myself. You took it to your house. I have you on video loading it into the cart and driving it directly to your driveway. You used it in your own fireplace. That's not community use. That's theft. The room fell silent. Marcus Webb was looking at papers in front of him, probably trying to figure out the legal liability for the HOA. Sandra was staring at Patricia with an expression of betrayal and disappointment. Robert broke the silence. We sent you a demand letter 6 days ago, Mrs. Garrison. You have 8 days left to respond. I suggest you take it seriously because the alternative is small claims court, where my client will be seeking treble damages under Colorado theft statutes, court costs, and attorney fees. That's going to be significantly more expensive than just making this right now. This is blackmail, Patricia said, but there was no conviction in her voice. No, this is the legal process. Blackmail would be if we demanded something we weren't entitled to in exchange for not reporting a crime. We're demanding restitution for theft, which we have every right to do. You stole from my client. We have proof. We've filed a police report. Now we're giving you a chance to settle before this becomes a public court case. A police report. Marcus Webb looked up sharply. You filed with the sheriff, of course, Robert said. Theft is a crime. We have a case number and everything. The deputy who took the report was very interested in the video footage. Patricia stood up abruptly, her chair scraping against the floor. This hearing is over. The board will discuss this matter in executive session and inform Mr. Armstrong of our decision. There's nothing to discuss, Robert said, standing as well. My client wants his property returned or compensated, plus damages for what's already been used. That's not negotiable. You have 8 days. He picked up his briefcase and we walked out of the clubhouse together. In the parking lot, I let out a breath I didn't realize I had been holding. That went better than I expected. She's cornered and she knows it, Robert said. The other board members looked genuinely shocked. My guess is they'll pressure her to settle. No HOA wants a sitting president with a theft charge hanging over their head. Bad for property values. Over the next week, I heard through the neighborhood grapevine that there was turmoil in the HOA. Apparently, several board members had called an emergency meeting without Patricia. There were rumors that she might be asked to step down. I stayed out of it, continuing my work and waiting to see what would happen. On the 13th day after Robert sent the demand letter, we received a response. It wasn't from Patricia personally, but from the HOA's lawyer, a firm in Denver that specialized in community association law. The letter was bureaucratic and non-committal, essentially saying that they were investigating the allegations and requesting more time to respond. Robert called me after he received it. This is a stalling tactic. They're hoping you'll just give up or settle for less. We're not doing that. Tomorrow is the deadline, and if they haven't provided a satisfactory settlement offer by 5 o'clock, we're filing in small claims court first thing Friday morning. Friday morning arrived with no settlement offer. Robert and I met at the Boulder County Combined Courts building at 9 o'clock. The small claims court had a relatively simple filing process, and Robert had prepared all the paperwork in advance. We were suing Patricia Garrison personally for $900, which represented 3 times the value of the stolen firewood, plus court costs. The filing fee was minimal, and within 30 minutes, we had our court date scheduled for 6 weeks later in January. The court would serve Patricia with the summons, and then we would wait for our day in front of a judge. 2 days after we filed, I came home from a grocery run to find Patricia Garrison standing in my driveway. She looked different from the confident, aggressive HOA president I had dealt with before. Her hair was less perfectly styled, and she wasn't wearing makeup. She looked tired and stressed. "Mr. Armstrong," she said as I got out of my car, "can we talk?" "My lawyer advised me not to speak with you directly," I said, which was true. Robert had been very clear about that. "Please, just 5 minutes. I'm not trying to trick you or anything. I just want to explain." Against my better judgment, I agreed to listen, but I pulled out my phone and started a voice recording app. "I'm recording this conversation," I told her. "If that's okay with you, we can talk." She nodded, seeming defeated. "That's fine. Look, I messed up. I know I did." The firewood situation. It started because I was having financial problems. My husband lost his job last year and we've been struggling. I saw the wood in your unit and I knew you were using it, but I thought maybe you wouldn't notice if I took a little. And then I kept taking more because it was free heat and our gas bill was so high. I felt a flicker of sympathy, but it didn't excuse what she had done. "Why didn't you just ask? I might have given you some if you had explained the situation." I know that now, but I was embarrassed. I'm supposed to be the HOA president. I'm supposed to have everything together, and here I am, struggling to pay my heating bill. It felt humiliating. "So you stole from me instead." She looked down at her feet. "Yes. And then when you sent that letter, I panicked. I thought if I could make it about the camera, maybe I could shift the focus. It was stupid. I'm sorry." "Patricia, I appreciate you coming here and apologizing, I really do, but you didn't just take a little firewood. You took hundreds of dollars worth of my property over multiple trips. You used your position as HOA president to access my storage unit, and then you tried to intimidate me with a fake disciplinary hearing when you got caught. This isn't just about the wood anymore. This is about abuse of power." She nodded, tears starting to form in her eyes. "I understand. What do I need to do to make this right? I can't afford $900, but I can make payments. I'll do whatever it takes. You need to talk to your lawyer and make an official settlement offer through them to my lawyer. This conversation doesn't change the legal process. I'm sorry about your financial situation. I really am, but I can't just let this go." She wiped her eyes and nodded again. "Okay, I'll talk to the HOA's attorney tomorrow. Thank you for listening." She walked back to her white Mercedes, which now seemed like a symbol of the facade she had been maintaining while struggling financially. As she drove away, I felt conflicted. I hadn't started this fight wanting to destroy anyone. I just wanted my property respected and the theft to stop. But Patricia had escalated it at every turn, and now we were both committed to seeing it through. 3 days later, Robert called with news. The HOA's attorney reached out with a settlement offer. They're proposing that Patricia pay you $400 in restitution, return any remaining firewood she hasn't burned, and resign from the HOA board. In exchange, you drop the lawsuit and agree not to pursue criminal charges further. What do you think? I asked. It's not terrible, but it's less than we'd likely get in court. With treble damages, we're asking for $900 plus costs. I think we can push for more. Also, I want something in writing that prevents her from retaliating against you through the HOA in the future. Let's push back. I want the full $900. She had multiple opportunities to make this right before we filed suit. The time for a discount has passed. Robert negotiated back and forth with the HOA's attorney over the next week. They came up to 500, then 600. We held firm at 900. Finally, 10 days before our court date, they agreed to $750 plus Patricia's resignation from the board, return of any unused firewood, and a signed agreement that she would have no role in any HOA decisions affecting me for the next 5 years. I considered it. It was less than the full amount we were seeking, but it was more than the actual value of the wood, and it guaranteed Patricia would be removed from power. However, something bothered me about letting her off easier. She had used her position to steal from a homeowner, then tried to weaponize that same position to cover it up. That felt like something that needed to be fully adjudicated, not swept under the rug with a settlement. "Robert, I want to go to court," I said. "I appreciate the settlement offer, but I think this needs to be decided by a judge. If we settle, it stays quiet. If we go to court, it becomes public record. Other people in the community need to know what happened." Robert was quiet for a moment. "That's your right, and I understand the reasoning. But I want to make sure you understand that court is always a risk. We have excellent evidence, but judges can be unpredictable. We might get the full 900, or we might get less than the settlement offer." "I understand. Let's go to trial." The court date was January 14th, a cold Thursday morning with snow flurries drifting across Boulder. The courthouse was busy, with various cases being heard throughout the building. Small claims court was held in a smaller courtroom on the second floor, with simple bench seating and a more informal atmosphere than what you'd see on television legal dramas. Robert and I arrived early and set up at the plaintiff's table. I had dressed in my best suit, and I had organized all our evidence in a binder with tabs for easy reference. Robert had coached me on courtroom etiquette and what to expect during the proceedings. Patricia arrived 15 minutes before the hearing was scheduled to start. She was accompanied by the HOA's attorney, a man in his 50s named Gerald Hoffman. They sat at the defendant's table, and I noticed Patricia kept glancing over at us nervously. The judge entered promptly at 9 o'clock. Judge Margaret Riley was a woman in her 60s with gray hair pulled back in a bun and reading glasses perched on her nose. She had a reputation, Robert had told me, for being no nonsense but fair. "Case number 24-SC-8732, Armstrong versus Garrison," the clerk announced. Judge Riley looked over her glasses at both tables. "Good morning. This is a small claims matter regarding alleged theft of firewood. Mr. Armstrong, you're the plaintiff. You're represented by Mr. Chen. Mrs. Garrison, you're the defendant, represented by Mr. Hoffman. Before we begin, I want to confirm that both parties understand this is a bench trial, meaning I will be deciding the outcome, not a jury. Is that clear to everyone?" We all acknowledged our understanding. "Mr. Chen, please present your case." Robert stood and gave a concise opening statement outlining the facts of the case. He explained how I had purchased and stored the firewood, how it had been stolen over multiple occasions, and how we had video evidence proving Patricia was the thief. Then he called me to testify. I took the witness stand and was sworn in. Robert walked me through the timeline of events, asking me to explain when I bought the firewood, where I stored it, when I noticed it was missing, and what steps I took to investigate and document the theft. I kept my answers clear and factual, avoiding emotional language or speculation. Then Robert introduced the video evidence. He had prepared a compilation that showed all 6 instances of Patricia entering my storage unit and taking firewood. The video was played on a laptop positioned so that Judge Riley could see it clearly. The courtroom was silent as we watched Patricia, in high-definition color, systematically stealing my property over a period of several weeks. When the video ended, Judge Riley made some notes on her legal pad. That's quite compelling evidence, Mr. Chen. Mr. Hoffman, do you dispute the authenticity of this video? Gerald Hoffman stood. No, Your Honor, we don't dispute that the video is authentic. However, we have a different interpretation of what it shows. I'm listening. Your Honor, Mrs. Garrison believed the firewood had been abandoned. The HOA bylaws require that storage units not be used for long-term storage of bulk materials like firewood. Mrs. Garrison, as HOA president, was acting under what she reasonably believed was her authority to clear out materials that violated community standards. I nearly stood up to object, but Robert put a hand on my arm to keep me seated. Judge Riley looked skeptical. Mr. Hoffman, can you show me where in the HOA bylaws it prohibits storage of firewood in the storage units? Well, Your Honor, it's not specifically mentioned, but the bylaws do state that storage units should be used for household items and equipment. And is firewood not a household item for someone with a wood-burning fireplace? The interpretation is somewhat ambiguous, Your Honor. It seems pretty clear to me, but let's set that aside for a moment. Even if we accept your argument that the firewood violated some storage policy, does the HOA bylaws give the president authority to confiscate property without notice to the homeowner? Hoffman hesitated. The bylaws do give the board authority to address violations. That wasn't my question. Does it give the president authority to take someone's property without notice? Not explicitly, Your Honor. I didn't think so. And Mr. Hoffman, where did this allegedly abandoned, policy-violating firewood end up after your client removed it from Mr. Armstrong's storage unit? Another hesitation. It was used by Mrs. Garrison at her residence, for personal use. Yes, Your Honor. So even under your interpretation, that Mrs. Garrison was enforcing an HOA policy, she then took the confiscated property for her own personal benefit rather than disposing of it or returning it to the owner. Mrs. Garrison believed she was entitled to compensation for her time in dealing with the violation. Judge Riley removed her glasses and looked directly at Hoffman. Counsel, that's absurd and you know it. This isn't enforcement of an HOA policy. This is theft with the added aggravation of abuse of authority. Call your witness. Patricia took the stand and was sworn in. She looked small and scared, nothing like the imperious HOA president I had dealt with for 3 years. Hoffman asked her basic questions about her role with the HOA, her understanding of the bylaws, and her version of events. She stuck to the story that she believed she was enforcing rules, but under cross-examination from Robert, that story fell apart. Mrs. Garrison, Robert began, did you at any point before taking Mr. Armstrong's firewood send him a notice of violation? No, I didn't think that was necessary. Did you discuss the alleged violation with any other board members before taking action? No, I handled it myself. Did you document your actions in any HOA records? No. Did you place the firewood in a common area or HOA storage, or did you take it directly to your personal residence? Patricia's voice was barely audible. I took it to my house, and you burned it in your own fireplace for your own use. Yes, Mrs. Garrison, isn't it true that you took the firewood because you were having financial difficulties and wanted to reduce your heating costs? Hoffman objected. Relevance, Your Honor. I'll allow it, Judge Riley said. It goes to motive. Answer the question, Mrs. Garrison. Patricia's eyes welled up with tears. Yes, my husband lost his job and money was tight. I saw the wood and I justified taking it by telling myself it was violating HOA rules. But really, I just wanted free firewood. I'm sorry. The admission hung in the air. I almost felt bad for her in that moment, but then I remembered the disciplinary hearing, the intimidation tactics, the refusal to make things right until she was cornered. Robert concluded his cross-examination, and Hoffman had no redirect questions. Judge Riley asked if there were any other witnesses, and when both sides said no, she moved to closing arguments. Robert stood and made his case for treble damages. Your Honor, Colorado Revised Statute Section 18-4-405 allows for treble damages in cases of theft where the conduct was willful and malicious. Mrs. Garrison didn't just take firewood once. She returned 6 separate times over several weeks. She used her position as HOA president to access my client's storage unit. When confronted with evidence of her theft, she attempted to retaliate by initiating a sham disciplinary hearing against my client. This is exactly the kind of willful and malicious conduct that treble damages are designed to address. The actual value of the stolen firewood is approximately $300 based on current market rates for seasoned oak. We're asking for $900 in damages, plus court costs and reasonable attorney fees. Hoffman made a brief closing argument, again trying to frame it as a misunderstanding about HOA authority, but his heart didn't seem to be in it. Even he seemed to recognize that Patricia's courtroom admission had sealed her fate. Judge Riley took only a few minutes to render her decision. I've reviewed the evidence and heard the testimony. This is one of the more clear-cut cases I've seen in small claims court. Mrs. Garrison, you stole from Mr. Armstrong. You used your position of authority to access his storage unit, and you took his property for your own personal use. Your attempt to justify it as HOA enforcement is unconvincing, and your own testimony contradicts that narrative. The video evidence is indisputable. You committed theft, and you did so repeatedly over an extended period. She paused to write some notes, then continued. Under Colorado law, I can award treble damages when theft is willful and malicious. Given that you returned to steal more firewood on 6 separate occasions, and given that you attempted to use your HOA authority to retaliate against Mr. Armstrong when he caught you, I find that your conduct easily meets that standard. I am awarding Mr. Armstrong $900 in treble damages, plus $475 in court costs and attorney fees. Mrs. Garrison, you are ordered to pay a total of $1,375 to Mr. Armstrong within 30 days. Patricia put her face in her hands. Hoffman put a consoling hand on her shoulder but said nothing. Judge Riley wasn't done. Additionally, Mrs. Garrison, I am strongly encouraging you to consider this a wake-up call. As HOA president, you hold a position of trust within your community. You violated that trust in the worst possible way. I cannot order you to resign from the board, as that's outside the scope of this case, but I would suggest that stepping down would be in everyone's best interest, including your own. Do you understand the judgment I've entered? Patricia nodded, unable to speak. For the record, the defendant nodded in the affirmative. This court is adjourned. Robert and I gathered our materials and left the courtroom. In the hallway, he shook my hand. That went about as well as it possibly could have. Treble damages, full court costs, and attorney fees. The judge threw the book at her. I feel like I should be happier about winning, I said, but honestly, I just feel tired. That's normal. Litigation is exhausting even when you win, but you did the right thing. She abused her power, and now there are consequences. That matters. Over the next week, word spread through Pine Ridge Estates about the court case. Small claims court judgments are public record, and several residents looked up the case details. The neighborhood gossip network went into overdrive. I heard from multiple people that there was a petition circulating to recall Patricia from the HOA board. The bylaws required a vote of at least 60% of homeowners to remove a board member, and the petition apparently exceeded that threshold in less than a week. Patricia resigned before the recall vote could be held. A terse email went out to all residents announcing her resignation effective immediately, citing personal reasons. The board appointed Marcus Webb as interim president and scheduled a special election to fill the vacancy. The payment of the judgment was more complicated. Patricia didn't have $1,375 available in cash. Through her attorney, she proposed a payment plan of $250 per month. Colorado law allows judgment creditors to garnish wages or place liens on property if judgments aren't paid, but I agreed to the payment plan. Robert drew up a formal agreement that included interest on the unpaid balance and acceleration clauses if Patricia missed any payments. The first payment arrived on time, a cashier's check for $250. So did the second and third. By April, I had received $750 of the total judgment. Patricia seemed to be making a genuine effort to meet her obligations. During this time, the HOA board underwent significant changes. Marcus Webb, as the new president, implemented new policies about board member conduct and conflicts of interest. He also changed the locks on all the storage units and implemented a key checkout system so that there would be a record any time a board member accessed a unit. The changes were announced in a community meeting where Marcus explicitly referenced recent events as the catalyst for reform. I attended that meeting, and several neighbors came up to me afterward to thank me for standing up to Patricia. One woman told me that Patricia had been making her life miserable with petty violation notices for years, and she was relieved to finally have a board that seemed more reasonable. Another resident mentioned that he had suspected Patricia of going through his storage unit as well, but had never been able to prove it. That comment bothered me. If Patricia had been stealing from other people, I wanted to know about it. I suggested to Marcus that the board should send out a notice to all residents, asking if anyone else had experienced missing property from their storage units. Marcus agreed, and a notice went out the following week. 3 residents reported possible thefts from their storage units, though none had the kind of clear evidence I had. One man said he was missing some power tools, another reported missing camping equipment, and a third said some holiday decorations had disappeared. Without evidence, there was nothing we could do legally, but it painted a picture of Patricia's misconduct being more extensive than just my firewood. In May, something unexpected happened. I received a call from a reporter at the Boulder Daily Camera, the local newspaper. She had been researching HOA disputes in Boulder County for a story and had come across the public record of my case against Patricia. She wanted to interview me about HOA abuse of power. I was hesitant at first, but Robert encouraged me to do it. "This is a bigger issue than just your case," he said. "HOAs across the country have serious problems with accountability. If you tell your story, it might help other people who are dealing with similar situations." I agreed to the interview. The reporter, Angela Torres, met me at a coffee shop in downtown Boulder. We talked for over an hour about the Firewood theft, the video evidence, the attempted intimidation through the disciplinary hearing, and the court case. She was particularly interested in the abuse of authority angle. "What do you think should be done to prevent this kind of thing?" she asked. "I think HOAs need more transparency and accountability," I said. "Board members shouldn't have unilateral access to resident property without documentation and oversight. There should be regular audits of how board members use their authority, and residents need to know that they can challenge the board without fear of retaliation. The article ran 2 weeks later on the front page of the local news section. It was titled, "When HOA Power Goes Unchecked, Boulder Man's Firewood Theft Case Exposes Problems with Community Association Governance." The article told my story in detail, including Patricia's name and the court judgment. It also included interviews with other residents from Pine Ridge Estates who talked about Patricia's aggressive management style. The article got significant attention, both locally and online. It was picked up by a few Denver news outlets and shared widely on social media. I received emails and messages from people across Colorado and even other states who had dealt with similar HOA problems. Some of the stories were heartbreaking. Tales of elderly residents being fined into bankruptcy over minor violations, or veterans being threatened with foreclosure over disputes about flagpoles. The attention led to unexpected consequences. The Colorado State Representative for our district, a woman named Jennifer Kovac, reached out to me through the newspaper. She wanted to discuss potential legislation to increase HOA accountability and transparency. I met with her at the state capitol in Denver in June. "Your case really highlighted some gaps in our laws," Representative Kovac said. "HOA board members have significant power over residents' property rights, but there's very little oversight. I'm working on a bill that would require regular audits of HOA finances and operations, establish clear protocols for board member access to common areas and storage facilities, and create stronger protections against retaliatory actions by boards. Would you be willing to testify in support of such legislation?" I agreed without hesitation. The idea that my frustrating experience with Patricia could lead to systemic change was appealing. Over the summer, I worked with Representative Kovac's staff to draft testimony and provide input on the proposed legislation. The bill was introduced in the fall legislative session with bipartisan support. Meanwhile, back in Pine Ridge Estates, life gradually returned to normal. The new HOA board, led by Marcus Webb, was far more reasonable and responsive than Patricia's administration had been. Violation notices decreased dramatically, and when they were issued, they were for legitimate problems and came with reasonable timelines for correction. The community felt more relaxed, less like a police state. Patricia continued making her monthly payments on the judgment. I would occasionally see her around the neighborhood, usually driving past in her Mercedes or walking her dog. We never spoke. She would look away whenever our paths crossed, and I didn't push for interaction. I had gotten what I wanted: restitution, accountability, and systemic change. In September, nearly a year after the Firewood theft began, I received the final payment from Patricia. The total judgment was satisfied, including the accrued interest. Robert sent her a formal satisfaction of judgment, which was filed with the court. It was finally over. That fall, I was invited to testify before the Colorado House Committee on Local Government regarding Representative Kovac's HOA reform bill. The hearing room was packed with residents from across the state who had experienced HOA problems. I told my story, emphasizing the importance of checks and balances in community governance. "I'm not against HOAs," I testified. "They serve important functions in maintaining communities, but power without accountability inevitably leads to abuse." My case involved Firewood, which might sound trivial, but the underlying issues are serious. When board members can access your property without documentation, take your belongings without consequences, and retaliate against you for complaining, that's a fundamental violation of property rights. We need laws that protect homeowners while still allowing HOAs to function effectively. The bill passed the committee and eventually became law in Colorado, requiring annual audits of HOAs with more than 50 units, establishing protocols for board member access to common areas and resident property, and creating a state office to handle HOA complaints. It wasn't perfect, but it was progress. As for Patricia, I heard through the grapevine that she and her husband moved out of Pine Ridge Estates about 18 months after the court case. I don't know if the shame of the situation drove them away, or if they found better economic opportunities elsewhere, or if they just wanted a fresh start. I didn't ask. I was content to let her fade into my past. Looking back on the whole experience, I learned several valuable lessons. First, documentation is everything. Without that wildlife camera, I never would have been able to prove what Patricia was doing. Second, standing up to bullies, even those with institutional authority, is worth the hassle. Patricia had been terrorizing residents for years, and nobody had seriously challenged her until I did. Third, individual cases of injustice can spark broader change if you're willing to speak up about them. My firewood storage area remains secure, and I've had no further thefts. I still burn oak in my fireplace during cold Colorado winters, and I still find it therapeutic to watch the flames while I work on code. But now, every time I light a fire, I'm reminded of the importance of protecting your rights and holding powerful people accountable for their actions. The new HOA board installed security cameras throughout the common areas of Pine Ridge Estates, including the storage facility. Residents received notifications whenever a board member accessed a storage unit, with the reason for access documented in HOA records. These simple transparency measures would have prevented the entire situation with Patricia, and I was glad to see them implemented. I kept in touch with Robert Chen, my lawyer, who became something of a friend through the process. He told me that he had used my case as an example in several other HOA disputes he was handling, and that the publicity had led to more people feeling empowered to challenge HOA overreach. He estimated that at least a dozen residents across Boulder County had successfully stood up to their HOAs in the year following my case, citing the precedent and the new awareness of accountability. My testimony at the state capitol also had ripple effects I hadn't anticipated. I was contacted by HOA reform advocates in other states who wanted to use Colorado's new law as a model for legislation in their jurisdictions. I did phone interviews with groups in Arizona, Texas, and Florida, all states with large numbers of HOAs and documented problems with board misconduct. It felt good to contribute to a movement larger than my own situation. One unexpected positive outcome was that the experience made me more engaged with my community. Before the firewood theft, I had been somewhat isolated, working from home and keeping to myself. The court case and its aftermath forced me to interact with neighbors, attend HOA meetings, and become active in community governance. I even ended up joining the HOA board myself when a vacancy opened up the following year. I figured I owed it to the community to help maintain the improved standards that Marcus and the others had established. As an HOA board member, I pushed for even more reforms. We implemented quarterly community forums where residents could voice concerns directly to the board without fear of retribution. We created a simple online portal where residents could check HOA financials and meeting minutes. We established term limits for board positions to prevent any one person from accumulating too much power for too long. These weren't revolutionary changes, but they made Pine Ridge Estates a better place to live. I also made sure that new board members understood the lessons from the Patricia situation. During board orientation, we discussed the importance of respecting resident property, documenting all board actions, and never using HOA authority for personal benefit. We used my case as a cautionary tale, a reminder that even well-intentioned people can cross ethical lines when power goes unchecked. Years have passed since Patricia Garrison took that first load of firewood from my storage unit. The incident that seemed so frustrating and unfair at the time ultimately became a catalyst for positive change, not just in my community, but across Colorado. The judge's decision to award treble damages sent a clear message that theft by those in positions of authority would be taken seriously. The publicity around the case sparked conversations about HOA reform, and the legislation that followed created real protections for homeowners. I still live in Pine Ridge Estates, and I still enjoy my wood-burning fireplace. But now, when I stack firewood in my storage unit each fall, I do so with the confidence that it will still be there when I need it. That sense of security, that basic expectation that your property will be respected, is something I never take for granted anymore. It's a right I had to fight for, and in fighting for it, I helped ensure that others wouldn't have to go through what I did. The white Mercedes with the Rules 1 cent vanity plate is long gone from our neighborhood, replaced by families who treat the HOA as a tool for community benefit rather than personal power. And every time I light a fire with that oak firewood I buy each year, I'm reminded that justice, while sometimes slow and frustrating to achieve, is worth pursuing. Patricia Garrison learned an expensive lesson about the consequences of stealing and abusing authority, and I learned that one person standing up for what's right can make a difference that extends far beyond their own situation.